All right, everyone. Welcome back. We have a very interesting update in one of the many lawsuits against Scientology's tiny little leader, David Miscavige. And this was one of the lawsuits that, if it had not, about a year ago, if it had not been derailed into internal religious arbitration, was one of the much more scary lawsuits for Scientology and David Miscavige, especially because of David Miscavige's personal involvement in the complaints in this lawsuit. And I actually haven't done an update in this lawsuit because it was a little confusing to me what was going on. Plus, it was all bad news. You know, a year ago, it was ordered into religious arbitration. That was all kind of bogged down. Wasn't really clear what was happening. And thanks to a new Supreme Court decision, the lawyers representing the plaintiffs in this case are now appealing to Judge Thomas Barber, Federal District Court, Middle District of Florida, to reconsider his decision from March of last year, directing this lawsuit to religious arbitration. What was amazing about the judge's decision last year that this case had to go to arbitration is that even he said that he didn't think this made any sense, and that that this could possibly have to go to internal religious arbitration, especially because one of the main things at issue was whether the agreements that the three plaintiffs signed, agreeing to take all of their complaints to internal religious arbitration, was signed under duress. And the plaintiffs' legal team was arguing, Your Honor, you have to rule or decide, or can rule and decide, this court, are allowed to rule and decide that these arbitration agreements were signed under duress and therefore shouldn't even be enforceable, and there's no way we should go to arbitration. And the judge basically said, I'm sorry, but based on existing Supreme Court precedent, believe it or not, it's actually up to the arbitration committee to decide whether the arbitration agreement was signed under duress, which to any sensible thinking person is insane. And the judge even agreed that, admitted that it was kind of insane, but his hands were tied. And to reinforce his belief that, you know, he really didn't think this was right, but it's what he had to do, he allowed the plaintiff's legal team to appeal his decision about the arbitration agreements, even though technically he didn't have to, because normally you can only appeal once everything is all done. The last case that involved Scientology religious arbitration, Luis Garcia, he was required to go through the entire internal religious arbitration process before his team was allowed to appeal the entire thing. In this case, the plaintiff's team said, Your Honor, may we please ask permission to file an interlocutory appeal, which means let us appeal this decision right now before we move forward, considering this decision right now means everything. And the judge said, yes, absolutely, you can do that. Well, the plaintiff's team made that interlocutory appeal, and the appeals court said, no, thank you. We're not going to take this up at this time. Okay, so then it was like, and that was like crushing, because it's like, oh my God, yet another former Scientologist, in this case, 3 former Scientologists, 3 former Sea Org members, 3 people who had been practically born, some born and raised, some practically born and raised in the Sea Org, having to subject themselves to the unbelievably abusive, one-sided sham process that Scientology calls its internal religious arbitration. Okay, I have the actual filing for you. This was just made a few days ago. This is super interesting. I've reviewed it in advance so as not to bore you with all the paragraphs that I don't really understand. Let's just take a look at this, you guys. We won't spend too much time on this. Okay, the 3 plaintiffs in this case, Gawain Baxter, Laura Baxter, Valeska Paris. I believe all 3 of these plaintiffs currently reside in Australia. This case is being litigated in federal district court in Tampa. It would be my dream for this case to actually make it to trial, and I would be able to actually cover it in person in the federal courthouse in Tampa every single day. One can only hope. Praise Xenu. Okay, Gawain Baxter, Laura Baxter, Valeska Paris versus David Miscavige, Church of Scientology International, Religious Technology Center, IA, International Association of Scientologists, Church of Scientology, a flag service organization, and the Free Winds Ship, Church of Scientology flagship service organization. Okay, so let's take a look at this. Motion for reconsideration due to intervening change in controlling law. On May 23rd, 2024, the Supreme Court unanimously decided Coinbase Inc. versus Suski. I don't know if it's Suski or Suski, but I'm going to try to say it Suski every time I see the word. The Supreme Court unanimously decided Coinbase versus Suski, wherein it explained that a party seeking to avoid arbitration need not challenge an arbitration provision on grounds unique to that provision and may instead challenge the provision on grounds that apply equally to the whole contract of which the arbitration provision was part. One of the crazy things about the proceedings in this case and the ruling that the judge had to make is that, and this is to the best of my recollection and to the best of my understanding, there was an argument being made that if you sign a whole contract and the contract has one clause about arbitration, that you can't argue, you have to argue that the specific arbitration clause was signed under duress. You can't just argue that the entire contract was signed under duress. Somehow that's not good enough. You have to somehow argue that the exact clause itself was signed under duress. And I hope I'm not misremembering that, but I think I'm remembering it correctly, and it was absolutely bonkers. Okay, and so that's why this is being pointed out here. That literally just, well, last month, a new decision came down that if you're seeking to avoid arbitration, you do not have to challenge an arbitration provision on the grounds unique just to that provision, but you may challenge it on grounds that apply equally to the whole contract of which the arbitration provision was a part. Okay. The Supreme Court unanimously clarified its previous opinions. Quote, a party seeking to avoid arbitration must directly challenge the arbitration and delegation clause, not just the contract as a whole. This is the language of the previous ruling that basically had the judge's hands tied. It goes on. But this rule, well, actually, let me just continue. But this rule does not require that a party challenge only the arbitration or delegation provision. Rather, where a challenge applies equally to the whole contract and to an arbitration or delegation provision, a court must address that challenge. Okay, so this language is stating the original ruling and then clarifying it. Again, basic principles of contract and consent require that result. Arbitration and delegation agreements are simply contracts. And normally, if a party says that a contract is invalid, the court must address that argument before deciding the merits of the contract dispute. Super, super interesting. And what a happy coincidence that a ruling such as specific as this, as targeted as this, and as relevant to this Scientology lawsuit came down. Like, what a gift. Okay, let's read a little bit more of this. In light of that intervening change in the law, plaintiffs moved for reconsideration of this court's March 31st, 2023 order compelling arbitration of their claims against the defendants, including its decision that the threshold issue of whether the arbitration agreements the plaintiffs signed were invalid because they were entered under duress or procured by fraud in the execution is a question for the arbitrator, not the court, to decide. Reconsideration is warranted because under Suski, all plaintiffs' challenges to the arbitration provisions, including their duress and fraud in the execution challenges, must be considered by a court, not an arbitrator. But this court held, based on the pre-Suski Supreme Court precedent, that was not a model of clarity, that those challenges must be heard by the arbitrator. At the time, the court found that result surprising and shocking. That is totally correct, you guys. When Judge Thomas Barber in this Scientology lawsuit issued his ruling that this lawsuit had to go to internal arbitration based on Supreme Court precedent, he said this was, what was the word? Surprising and shocking. It seems that a judge who was willing to admit that would also, fingers crossed, you guys, praise Enu, be willing to review and overturn his own decision based on this new Supreme Court clarification. Okay, but the court found that the result was surprising and shocking, but felt that its hands were tied by existing Supreme Court case law. Now that Suski has clarified the controlling law, this court should grant reconsideration and avoid that surprising and shocking outcome by hearing and adjudicating plaintiffs' challenges to the arbitration agreement. In particular, the court should find as a matter of law that the arbitration agreements were never formed due to duress, fraud in the execution, or lack of mutual consent. And if it cannot do so as a matter of law, it should hold a trial under the Federal Arbitration Act regarding the formation of the arbitration agreement. That's right. So instead of just trying this case on its complaints, they can actually hold, I guess, what I'm going to call a mini trial specifically on the subject of how these arbitration agreements are executed. So actually holding a trial to determine the truth or falsity of whether these arbitration agreements are executed under duress or fraud in the execution, or there was or lack of mutual consent. Oh my God, that would be such a blessing just to have that mini trial. And I don't know, you can never read too much into, what a judge thinks or feels, but it really did seem that the judge was regretful that the prevailing language of Supreme Court precedent had tied his hands. Now that that precedent has been clarified and technically speaking, his hands are untied, this lawsuit that seemed like it had been on ice and was just doomed to die a quiet death might now come back to life with a fresh, sharp set of teeth. This is pretty exciting, you guys. All right, let's see here. All right, I'm going to jump forward now to page 9 of this bad boy. I guess let's go back to page 8. All right, here. We'll jump in. We'll jump in right here. Reconsideration is especially necessary here to prevent injustice. As the court recognized, it is a shocking result for plaintiffs to be forced into Scientology arbitration under an agreement they contend, supported by compelling evidence, was never formed in the first place because it was procured by duress and fraud in the execution. And now that the Supreme Court has clarified that such a result is not required by its case law, it would be unjust to uphold it. While compelling arbitration under an agreement that was never formed due to duress or fraud would be unjust in any arbitration, it is especially so here because since the motions to compel arbitration were decided, new evidence has come to light, confirming plaintiffs' argument that the Scientologist arbitrators, who are controlled by the defendants, will not give plaintiffs a fair hearing on the issue of whether they signed the agreements under duress, including that plaintiffs will be denied an attorney to represent them and prevented from presenting evidence or witnesses to support their duress argument. And then it refers to another lawsuit that I have actually spoken about recently, which is the lawsuit that was brought by Val Haney, the woman who worked directly for David Miscavige and Shelley Miscavige, and a number of years ago had to literally escape from Scientology's secretive international management base out in the desert in California by jumping into the trunk of a car of a non-Scientologist actor who was on the base just for the purpose of shooting one of Scientology's films. She jumped into the trunk of a car of a complete stranger without the driver's knowledge and stayed in that trunk all the way, I don't know, about a 90-minute drive back to LA when she popped out like a jack in the box. Surprise! And in Valerie's case, what happened is, even though Valerie had escaped, they used the pressure of enforced familial disconnection, because Valerie's family was still in Scientology, to pressure Valerie to come back to the base and leave on Scientology's terms, which means undergo the extensive, invasive, abusive interrogations and to sign a whole mess of forms saying David Miscavige is great, Scientology is great, you're a piece of crap, you weren't able to uphold the high ethical standards of the Sea Organization and Scientology, and they make you sign that form again, promising never to sue Scientology. Well, unfortunately, in Valerie Haney's case, the judge also ruled that she had to go to internal religious arbitration. Valerie is still presently undergoing that arbitration process. And I think she's completed 5 full days of it now. They do like a few days here and then a couple days a few months later. And then Scientology recently asked for 5 more days in like August or something, or February, some crazy, far out date. After every one of Valerie Haney's arbitration sessions, you might call them, her team has been filing updates with the court just to make sure there's no question about how horrifically unfair and one-sided the procedure Valerie Haney is being subjected to is. And that is what is being referred here in this affidavit. And with that context, I just want to read it to you again. Okay. While compelling arbitration under an agreement that was never formed due to duress or fraud would be unjust in any arbitration, it is especially so here because since the motions to compel arbitration were decided, new evidence has come to light confirming plaintiff's argument that the Scientologist arbitrators, who are controlled by the defendants, will not give plaintiffs a fair hearing on the issue of whether they sign the agreements under duress, including that plaintiffs will be, and guys, the rest of the sentence is everything that Valerie Haney has been subjected to, denied an attorney to represent them, prevented from presenting evidence or witnesses to support their duress argument. Scientology doesn't even allow the people that, and by the way, the only people who've ever undergone a so-called internal religious arbitration are only ex-Scientologists. You see, this is an entirely made up fraudulent sham procedure. It doesn't exist. It's not a real thing in Scientology. There's no such thing as internal religious arbitration in Scientology. A Scientologist could never and would never participate in an internal Scientology religious arbitration. It's not something that exists in Scientology. So it's only something that former ex-Scientologists who Scientology has already said are evil, bad, suppressive persons. It's only when those people are suing Scientology that Scientology goes, Your Honor, we have this thing called religious arbitration, and these evil people have to subject themselves to it. Okay, so Scientology doesn't even allow the people participating in this to record the proceedings. You can't even audio record the proceedings. You cannot even have an attorney present who could then later swear in an affidavit as to what occurred in the proceedings. So what happens in Valerie's case, she submits these affidavits to the court trying to explain how insanely unfair and one-sided this procedure is. And because there's no record of the procedure, Scientology just files a counter affidavit saying, Your Honor, she's totally lying. And this is none of your business. This is a religious matter. We'll get back to you when we're done. It's bonkers, you guys. It's hard to wrap the mind around. Okay, so let's see. Thus, now that Suski has clarified that this court has authority to decide whether the arbitration agreements at issue here are valid, the court should take the opportunity to avoid a shocking and surprising result and ensure that plaintiffs are not forced to participate in Scientology arbitration unless they freely agreed to do so. Conclusion: for the foregoing reasons, plaintiffs' motion for reconsideration of the court's March 31, 2023 order should be granted, and the court should decide plaintiffs' challenges to the validity and enforceability of the arbitration agreement. If the court cannot find that the arbitration agreements are invalid as a matter of law, plaintiffs renew their request for discovery and a trial on the issue pursuant to, I think, is it Section 4 of the FAA. Requesting that if the court finds that there is a dispute of material fact as to whether a valid arbitration agreement exists, that it proceed with discovery and a trial on any disputed issues of fact regarding arbitratability. Guys, I tend to have a very optimistic outlook on all of these Scientology lawsuits. I had become despondent with respect to this one. Like I said, it was thrown into arbitration well over a year ago. Absolutely nothing has happened with it. I didn't even know if anything would happen with it. Thank goodness the Supreme Court just happened to issue a new ruling on a case that had direct applicability to this one. I'm excited, you guys. I'm super excited. All right, Panko, welcome as a new member. Todd Grubb says, I need to quit my job so I can keep up with all of this. Anna says, I know it's not the point of this video, but is Mike Rinder a witness in this case? I don't think this case has progressed to the point where there are any witnesses. Yeah. Let's see. Better Together says, Reese is a gosh darn national treasure. Thank you for your thoughts, Better Together. Good to have you here. Vegan question. I'm trying to find that great interview that you did with the former Nation of Islam member. I think it was on his channel, as I cannot find it and I cannot remember his name. I wanted to rewatch. I feel like you were talking about an interview we were planning on doing, but never actually did. Yes. Okay. I'm looking for comments that are relevant to the video. Anna says, have Laura Baxter and Gawain Baxter ever been interviewed? I cannot find anything. Anna, I do not believe that Laura Baxter and Gawain Baxter have ever been interviewed. And it probably wouldn't be a good idea for them to do it during this lawsuit, which I know isn't what you're proposing. But I guess what I'm saying is if they weren't in the middle of the lawsuit, I would absolutely be trying to interview them. But no, I'm not. I've never seen an interview that any of them have done. Eat More Pizza Now. Thank you for gifting a channel membership. I really appreciate that. Circus Rider says, it violates part of the Fifth Amendment, which is due process. I agree with you. Mama D63. This is great news. It is great news. All right, guys, just a brief update. Thank you for hanging out with me. Stay tuned. So much more to come, and I'll talk to you soon.